Namaste everyone, my name is Pranav Anand and I belong to Faculty of Non Governance. In previous sessions, I dealt with criminal offences and civil cyber crimes, cyber offences, and cyber contravention. In the previous session, I raised concern regarding jurisdiction. So, let us try to deal with jurisdiction. This unit deals, this session will deal with jurisdiction and applicable laws with respect to computer crimes and offenders. And the issue of jurisdiction of courts and crimes is very confusing in the cyberspace and computer crimes. It is very easy to sit in New York and hack a computer in Jaipur and steal digital information than it would be for a thief to physically steal something from the neighborhood. So the digital world makes national and international borders a relic. The concept of borders would have become anachronous or archaic in the realm of cyberspace. Courts exercising jurisdiction on the basis of such national and international borders are left aghast by the speed and ease with which cyber criminal moves from one jurisdiction to another with the use of a click of a mouse. So the issue arising out of such activities at the foremost contains that of the jurisdiction of court. The question of which court shall have jurisdiction to entertain the matter, and then which law shall be applicable in such cases. So an inline environment, the offender and the victim might reside in different geographical locations governed by different procedural and substantive laws, probably in different countries. For instance, a person might open an online gambling website while sitting in Las Vegas. The website is open for all to see and use. It might be legal in Las Vegas, but when people access and make of this website, say in Qatar, Australia, or Indonesia, so the question of as to permissibility of offering to gamble might crop up. So it is in this light this session deals with the dispute resolutions in the realm of cyberspace. And after this session, a student might be able to explain the term jurisdiction and discuss this with importance in cyberspace and discuss various theories relating to cyber jurisdiction, criminal jurisdiction, quoting relevant provisions of Indian laws and court decisions. They analyze the importance of effect doctrine in the light of extraterritorial nature of cybercrime, and a student will be able to examine the issue of applicable laws with special reference to India by citing relevant sections of IT Act 2000. Now, let me start with the concept of jurisdiction. The jurisdiction means uh, comes from the word jurisdictio. Now, jurisdictio means the saying or speaking of law. It indicates the value, validity, and articulation of law. The concept helps to define and determine the power of the state to regulate property and circumstances within the territory of the state and extraterritorial also. Generally, there are three kinds of jurisdiction, that is legislative or prescriptive jurisdiction, enforcement jurisdiction, and adjudicative or judicial jurisdiction. Now, jurisdiction to legislate is the right of a state to prescribe the normative standards for the regulation of its subjects. However, the state has to take into consideration the limitation of international law in the exercise of jurisdiction in cases that involves non-territorial entities. The prescriptive jurisdiction of state is not unlimited, as the state would not like to prescribe a conduct for the enforcement of which there is no basis in the practical aspect. So, jurisdiction as applied to a particular claim or controversy is the power to hear and determine that controversy. The term the term the term imports authority to expound or apply the law and exclude the idea of power to make the laws. It refers to the right to adjudicate on a given point, the local extent within which the court can and does exercise the right when ascertained. The law relating to crime would generally require that the courts within a state would have jurisdiction to try and adjudicate upon all such offences committed by a person within the territorial boundaries of such a court. However, the exceptions have been created where, even though technically and strictly the offender might not have committed the crime on the soil of the country, yet the courts would exercise jurisdiction over such offender. Now, with this, let us come to the theories of jurisdiction in criminal cases. Now, we have to bear in mind that a state, while framing laws, exercises its legislative power to regulate, adjudicate upon, enforce measures against criminal actions. So, laws of regulation of criminal actions encompasses declaring certain acts or omissions to be a crime and provides for punishment thereof. So laws of adjudication provides for establishment of courts and defining their jurisdiction. Enforcement measures ensure that orders of the court are carried out and persons found guilty are appropriately punished. So there are six generally accepted bases of jurisdiction or theories under which a state may claim to have jurisdiction to prescribe a rule of law over an activity. Now, the first come is subjective territoriality. Now, this is by far the most important of the six. The substantial part of criminal legislation across the globe is based on the theory that if an activity takes place within the territory of a particular country, then the said country has the jurisdiction to regulate and punish for such activity. For instance, Section 2 of Indian Penal Code provides for punishment of offences committed within India. Now, second comes objective territoriality. Now, this is invoked where the action takes place when the action takes place outside the territory of the forum state, but the primary effect of that activity is within the forum state. So, basically, this is known as effects doctrine, where the action takes place outside the territory of a country, but the primary effect of that activity is within the said country. Now it assumes jurisdiction. For instance, a person from Pakistan shoots across the border and an Indian is injured in the process. Though the action was initiated in Pakistan, the effect was in India, and Section 179 of the CRPC endorses the effects doctrine. Now comes the third point, that is nationality. Nationality is the basis of jurisdiction, where the forum state asserts the right to prescribe a law for an action based on nationality of the actor. For instance, Section 4 of Indian Penal Code stipulates that the provisions of the code would also apply to any offence committed by any citizen of India in any place without and beyond India. Now comes passive nationality theory. Now, this is a theory of jurisdiction based on the nationality of victim. Passive and active nationality are often invoked together to establish jurisdiction because a state has more interest in prosecuting an offense when the offenders and the victims are nationals of that state. Now comes protective principle. The protective principle expresses the desire of a sovereign to punish actions committed in other places solely because it feels threatened by those actions. This principle is invoked where the victim would be the government or sovereign itself. This principle is not preferred for the obvious reason that it can easily offend the sovereignty of other nation. Lastly, nations also exercise a universal jurisdiction with respect to certain offences. Now, for example, sea piracy has been for a long part of time an element of this kind of jurisdiction. Any nation could have captured and punished pirates. This form of jurisdiction has been expanded lately to include slavery, genocide, and hijacking, that is, air piracy. For instance, Article 105 of United Nations Convention on the Law of the Sea stipulates that on the high seas or in any other place outside the jurisdiction of any state, every state may seize a pirate ship or aircraft, or a ship or aircraft taken by piracy and under the control of pirates, and arrest the person and seize the property on board. It further provides that the courts of the state which carried out the seizure may decide upon the penalties to be imposed and may also determine the actions to be taken with regard of the ships, aircraft and property, subject to the rights of third parties acting in good faith. But with the advent of internet and increase in cyber crimes, especially cross-border illegal activities, it is a matter of much concern to the courts whether they have the jurisdiction to put the offenders under trial and if found guilty eventually punish them. Now let's come to the general jurisdiction part of computer crimes. The law of jurisdiction with respect to crimes relating to computers is the same as relating to the computer crimes. The theory of subjective territoriality would apply. In India, Chapter 12 of the CRPC relates to the jurisdiction of courts with regard to criminal matters. The foremost and most commonly applied theory of territoriality is embodied in Section 177 of the Code, wherein the Code states for ordinary place of inquiry and trial, and it states that every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Thus, if any computer crime committed, let's say in Lucknow, then it would be tried by criminal courts in Lucknow itself. However, computer crime by its very nature is capable of being committed at more than one place at the same time. For instance, a person sitting in NLU Jodhpur can hack the computer at IIT Bombay through a proxy server located at Bijnor. In such situations, the offence can be inquired into and tried by a court having jurisdiction over any of such areas where the crime has been committed. Now, Section 178 of the CRPC provides for this kind of situation, wherein it states for place of inquiry or trial. Thus, based upon subjective territoriality theory and the above provisions that I mentioned, the requirement that our courts should have jurisdiction to book persons found guilty of committing crimes relating to computers within the territory of India is well taken care of. However, issues arise when someone is sitting across the border and initiates a digital action which has a direct adverse consequence within the territory of the state. Now it is when the effects doctrine that we will discuss in the further session assumes significance when offenders involved in cross-border crimes are required to be put on trial. Now, with this session has come to an end, and in coming session, I will talk about effects doctrine.